Good afternoon. My name is David Johnson, and I'm the author of the book, Irreconcilable Founders, Spencer Roane, John Marshall, and the Nature of America's Constitutional Republic. I'm greatly honored to have LSU Press as my publisher. This is our second collaboration, the first being my biography of John Randolph of Roanoke that was released in 2012. And working with the expert staff at LSU Press from the beginning of the process, from the submission of a manuscript through the editing and reviewing process right through publication, is professionally invigorating, personally delightful, and as I said, a great honor. Now, in looking at the title of this book, the name John Marshall strikes out with a familiarity that is bred of long historical association for most people. But the name Spencer Roane is met, except in small legal circles, with a deafening thud. And at first blush, there seems to be some reason for that. After all, John Marshall dominates the history of American constitutional jurisprudence. He served as Chief Justice of the United States Supreme Court from 1801 to 1835 and transformed that court from the weakest of the three branches of government into the institution that we know today. Marshall so dominated the court that during his tenure, he dissented on only 9 of the 1,106 decisions that were issued. There are 3 law schools and 1 university named for him, and his portrait, 12.5 feet tall and 7 feet wide, dominates the head of the grand staircase in the United States Capitol. And perhaps not coincidentally, the Liberty Bell cracked when tolling for John Marshall's funeral. Spencer Roane, on the other hand, has faded into a deep and dark historical twilight. No law schools or universities bear his name. His decisions that he wrote as a justice of the Supreme Court of Virginia are not widely studied or cited. His papers are scattered, and he appears in all studies of John Marshall only as an annoying gadfly. United States Supreme Court Justice Lewis Powell once quipped, quote, "Marshall wound up writing the law of the land, and Rhone wound up writing letters to newspapers," end quote. I was chided at a dinner several years ago by a constitutional law professor who, upon learning the topic of my book, said, "Spencer Roane, he was wrong about everything." Now, Rhone's historical atrophy would surprise his contemporaries, for in his time, Rhone was viewed as the court's chief ornament, Virginia's most powerful and influential politician, and the intellectual equal of Thomas Jefferson and James Madison. It was Rhone to whom Jefferson turned to combat what he viewed as the centralizing tendencies of national government. Quote, "I know no one," Jefferson wrote, "who equally with Judge Rhone himself possesses the power and the courage to make resistance, and to him I look and have looked as our strongest bulwark." Rhone was to the Virginia Supreme Court, on which he served from 1795 to his death in 1822, what Marshall was to the United States Supreme Court, its intellectual and philosophical leader and the author of the majority of its decisions. He established the independence of Virginia's judiciary and formulated the doctrine of judicial review of state legislative acts. The power of his intellect struck down the last vestiges of Virginia's established church and opened a path, albeit a narrow one, to emancipation for slaves. At the apex of his career, Rhone's influence extended beyond the judiciary and into the legislature, the press, and the Republican Party. Now, all that's very interesting, but Marshall's historical prominence over Rhone is based on the fact that Marshall's views of the Constitution and the nature of the Union ultimately prevailed. So why summon Spencer Roane from history's shadow? I leave it to the informed reader to draw his own conclusions, but I would suggest several reasons. First, one might argue that Rhone's positions are increasingly relevant in many current legal and policy debates. Rhone warned, quote, of legislative power, everywhere extending the sphere of its activity and drawing all power into its impetuous vortex. He anticipated, quote, the time will soon arrive, if it is not already at hand, when the Constitution may be expounded without ever looking at it, end quote. He asserted that the power of the Supreme Court, quote, does not extend to everything. It is not great enough to change the Constitution, end quote. And he believed that the debates over the nature of federalism, quote, is one which portends destruction to the liberties of the American people, end quote. As such, Spencer Roane piqued my interest, if for no other reason than to present his views for modern critique and analysis. Along the way, though, I found a very interesting character. Resolute and insightful with a powerful intellect, Rhone was also easily offended, touchy, and quick-tempered. He carried on such a vicious feud with a fellow judge on the Supreme Court that the judge resigned. It is very surprising that he never fought a duel. Rhone was both inspiring and ridiculous, sometimes displaying each respective trait within minutes of the other. This makes for a good story because Rhone is not a founder that's carved in marble, but he's a real character of personal eccentricities and philosophical centricities, of passion and principle. And no one could more easily get under John Marshall's skin. As Rhone put it, quote, no man is more sensible than myself of the comfort of passing down the stream of life quietly, but I am prepared to do my duty. I have always preferred the tempestuous sea of liberty to the calm of despotism, end quote. You can't pass up writing about a guy like that. Now, one problem presented itself. Writing the biography of a judge carries with it the danger of turning a book into a legal treatise, and I did not want to do that. But in order to properly and completely tell Rhone's story, it is necessary to address his judicial opinions in some detail. I attempted to do that in this book to offer historical context and not to offer a definitive analysis of Rhone's jurisprudence, which is interesting, but which is more properly addressed in a different type of book. Additionally, Rhone's opinions offered much insight into his personality. He was not shy about expressing himself, about straying from the legal issues before him, about making comments about lawyers, judges, politicians, and history. So his opinions frequently fill the role that a diary or extensive correspondence fill for other subjects. In short, you don't need to be an attorney to understand this book. It is critical, though, in understanding Rhone and viewing his actions through the years, in particular, his conflict with Marshall, that Rhone was an unabashed heir to the American Revolution. It never ended for Rhone because the revolution was not just about victory over Great Britain, but about the implementation of certain principles in a constitution republic. At age 13, he stitched liberty or death on his hunting shirt, armed himself with a tomahawk, and volunteered for the Virginia militia. The hero of his youth was Patrick Henry, and he memorized George Mason's Declaration of Rights, which he said, quote, must have been given by divine inspiration and ought to be written in letters of gold. His political views and judicial opinions consistently rejected the Lockean notion that all men are created equal in favor of Mason's language that all men are equally free and independent. Throughout his life, he zealously guarded this inheritance and he violently resented any perceived encroachment on it. He wrote, quote, having passed through the Red Sea of the Revolution and foiled a formidable tyrant in the conflict, the inestimable jewel then acquired is not to be lightly cast away. Ever mindful of the liberty interest of the individual citizen, Rhone viewed any exercise of power by the state through the lens of the tyranny of George III. Rhone was graduated from the College of William and Mary admitted to the bar in 1782 and elected to the Virginia legislature in 1783. He very quickly developed a strong political alliance and personal friendship with Patrick Henry, a position he enhanced by marrying Henry's daughter. He opposed ratification of the proposed U.S. Constitution, became a leading anti-federalist, and published what the Harvard Law Review identifies as the first printed opposition to the Constitution in the colonies. He might have opted to advance his views in the newly created Congress, but in 1789 he was elected a judge of the General Court in Virginia, and in 1794 he was named to the Virginia Supreme Court, where he served until his death. His opinions, a contemporary noted, were, quote, conspicuous for the analytic and discriminating powers of his judgment and the depth of his research on the most intricate and important subjects. Equally conspicuous was Rhone's dedication and devotion to his revolutionary heritage. His opinions, it was said, quote, incline to the side of liberty and abhor oppression. Rhone became the dominant member of the Virginia Supreme Court, despite never serving as Chief Justice. During the years 1813 to 1820, he authored 157 of 223 majority opinions, including 51 of 62 during the 1817 term. Now, all of these statistics would lead one to expect that Rhone settled into the sedentary life of a judge in the hushed surroundings of his chambers, but Rhone's service on the court did not reduce his political activities or soothe his temper. Both contemporaries and historians concur that during the Jeffersonian era, Rhone was the most powerful politician in Virginia. He exercised his political influence through a loosely organized group of business and professional men known as the Richmond Junto. The group consisted of men connected by familial ties, agrarian interest, and shared principles who influenced public policy and political activities. More often than not, Rhone's views form the canon of their orthodoxy. This doctrine was most prominently expressed in the pages of the Richmond Enquirer, the newspaper Rhone founded in 1804. The Enquirer's dominating influence in Virginia led John Marshall to huff, "There is no such thing as a free press in Virginia." Rhone was very close, politically and personally, to Thomas Jefferson, not so much to James Madison, and depending on what year it was, half and half with James Monroe. But all three of these Virginia presidents frequently sought Rhone's counsel and support, and they all looked to Rhone to combat the increasingly nationalist and centralizing decisions of John Marshall. Now, the dispute between Rhone and Marshall over the nature and scope of the Constitution is the subject of this book, and I cannot, in the time allotted to these remarks, go into a great detail of the conflict. But I want to try with a shorthand version of one case and try to show you the complicated mix of law and politics, public good and private gain, royal prerogatives and colonial independence, and the simmering dispute between Rhone and Marshall. This case has a number of names, as most cases do, due to the number of lawsuits and appeals involved with it, but it has come down through history by its most popular name, Martin versus Hunter's Lessee. Now, this involves involves the ownership of 300,000 acres of rich timber and tobacco land, which represented 1/3 of the populated area of Virginia. The land was a grant from the British Crown, dating to 1649, and by 1736 it had devolved on the 6th Lord Fairfax. In 1781, 5 years after Virginia declared its independence from Great Britain, Lord Fairfax, who remained loyal to Great Britain, died without direct heirs. His will conveyed his holdings in America to his nephew, Denny Martin, a British subject. In 1782, the Virginia legislature confiscated all property claimed by British loyalists, declared void the Fairfax grant, and divested Denny Martin of his inheritance. The state divided the Fairfax land and sold parcels to more than 200 purchasers. Denny Martin, now calling himself Denny Fairfax, brought an action in ejectment against the purchaser of one parcel of the grant. Denny Fairfax was represented by John Marshall. Now, while Fairfax's case was pending, the Continental Congress in 1783 completed the peace treaty with Great Britain. The treaty included an anti-confiscation clause stating that seized British property would be restored to loyalists. So that's your question. Who owns the Fairfax land? Does the Commonwealth of Virginia and the third-party purchasers by virtue of the confiscation, or does Denny Fairfax own it as heir to Lord Fairfax and by virtue of the peace treaty? That legal question is then further complicated by political considerations. This, as you might imagine, was a very well-publicized case, and it was before various courts in Virginia at the same time that Virginia was considering ratification of the United States Constitution. The potential impact of the Constitution and federal treaties on state actions was a significant issue of contention. Opponents of ratification argued that here was a federal treaty nullifying the confiscation actions of Virginia. That argument was gaining force in the Virginia Convention until John Marshall assured the convention that the Constitution would not retroactively affect state actions. Spencer Roane was present in the audience and took note of Marshall's assurances. The case then took another turn. Denny Fairfax grew weary of the litigation and offered his contested title for sale. John Marshall formed a syndicate and purchased much of the Fairfax land. At the same time, courts began to rule on a number of lawsuits involving the grant. Marshall no longer wanted to risk his investment to the vagaries of litigation. He was at that time a member of the Virginia General Assembly, so he proposed legislation to settle the matter. The Compromise of 1796 paid 20,000 pounds sterling to Denny Fairfax, awarded the choicest land to Marshall's syndicate, and cleared the title of tracts purchased by the third-party purchasers. That seemingly ended the matter to everyone's satisfaction. And attorneys and courts began to dismiss the cases and close files. But one case was inadvertently not dismissed, an oversight soon to become very important. And I trust everyone now is sufficiently confused as the status of the Fairfax land at this point. Now, John Marshall is now Chief Justice of the United States Supreme Court, and he is a land baron. He and his partners began to act the part. Some of the land acquired by the syndicate operated under a feudal remnant, under which tracts of land were sold to purchasers who nevertheless continued to pay rent to the previous owner. That was called quit rent, and it was due every year. Marshall's syndicate announced that it intended to resume collecting quit rent, and not just the current quit rent, but all the sums not paid during the previous years of litigation. Not surprisingly, angry landowners refused to pay the quit rent. Marshall wanted to file suit, but he recognized that any new action would be barred due to the Compromise of 1796, which settled all claims. In order to collect quit rent, Marshall would have to base his authority in the original land rights of the late lamented Lord Fairfax. While contemplating this conundrum, he discovered that Martin versus Hunter Lessee was the one case not dismissed following the compromise. Marshall had the case reinstated, and his attorneys argued that the Marshall syndicate possessed the rights conveyed by the British Crown to Lord Fairfax and secured by the Treaty of 1783. Thus, Marshall, the landowner, adopted precisely the opposite argument from the one that Marshall, the delegate, had presented at the ratification convention. The case eventually reached the Virginia Supreme Court, and Spencer Roane So what happened in court? Well, if you want to find out, you need to read the book. And I assure you that it is a rollicking good read about the back and forth that now takes place between Justice Rhone and Chief Justice Marshall. But one thing is clear. With Martin versus Hunter's Lessee, the battle between the Marshall Court and the Rhone Court over the nature of the Constitution was joined. And it set off a series of disputes which form the basis of this book. Round two, after Hunter's, came with Marshall's decision in McCulloch versus Maryland. And this is the case where Marshall made the famous pronouncement about federal authority and the necessary and proper clause, which you will recall, quote, "Let the end be legitimate, let it be within the scope of the Constitution, and all means which are appropriate, which are plainly adapted to that end, which are not prohibited, but consist with the letter and spirit of the Constitution, are constitutional," end quote. What is interesting here at this point is how Rhone and Marshall contend with each other in the wake of McCulloch. Following the decision, Rhone responded with 4 essays titled Hamden in the Richmond Enquirer in June 1819, in which he took aim at Marshall's expansion of implied authority. "The man must be a deplorable idiot," he wrote in one essay, "who does not see that there is no earthly difference between an unlimited grant of power and a grant limited in its terms, but accompanied with unlimited means of carrying it into execution," end quote. "The power of the Supreme Court," Rhone wrote, "is indeed great, but it does not extend to everything. It is not great enough to change the Constitution." Marshall decided to engage Rhone in the same forum. He adopted the name A Friend of the Constitution and sent 9 essays to the Alexandria Gazette. He barely concealed his contempt for Rhone, characterizing the Hamden essays as a ranting declamation and rash impeachment marked by bitter invective, hostility, and unjust and insidious insinuation. What you have then, though, is a situation where the head of the federal judiciary, Marshall, and the head of the most prominent state judiciary, Rhone, are having it out in the pages of newspapers. I guess an early version of Twitter. And although under assumed names, everyone knew who these writers were. This happened again in the wake of the case of Cohens versus Virginia, where Rhone again took to the pages of the Enquirer. Thomas Jefferson, after reading Rhone's essays, wrote, "It appeared to me to pulverize every word which has been delivered by Judge Marshall." Marshall, Jefferson wrote, quote, "was so completely refuted by Rhone that if it can be answered, I surrender human reason as a vain and useless faculty given to bewilder and not to guide us." Marshall didn't answer personally, but the reporter of the U.S. Supreme Court published responses about which Marshall knew and approved. Now, what is important about these essays, other than their entertainment value, is that they contain the most extensive discussion of federalism, apart from the debates at the various state ratification conventions. Here are 2 judges in the early days of the Republic arguing how federalism should work. Our nation had moved from philosophical to practical, and no one knew exactly how it ought to work. Marshall and Rhone were laying down opposing judicial guideposts as the nation moved out of the shadow of its founding. Now, Rhone would have argued that he was applying what the Revolution taught him, namely, that every political issue touches on the nature of the human soul, that the soul best flourishes in a state of liberty, and therefore there can be no compromise with or adoption to principles, forces, or policies that diminish liberty and ultimately the human soul. Applying these principles to a changing culture consigned Rhone to an agenda of resistance, but offered no justification to abandon his principles. Truth, Rhone believed, was not determined by how many people vote for it. Thomas Jefferson hoped that Rhone would be elected vice president of the United States in 1824 and then succeed to the presidency, but Rhone died at age 60 in 1822 from an unidentified illness. He was then assigned to the position of Marshall Court's public enemy number one by subsequent historians. At no time during American history, one wrote, not even in the court-packing battle of the 1930s, was there such a sustained root and branch attack on the Supreme Court, end quote. Yet Rhone was not attacking the Supreme Court. At no time did Rhone advocate for an alteration in the court's makeup or for term limits for its justices. He never disputed the court's right to engage in judicial review of federal legislative actions. He never adopted Jefferson's theory of tripartite interpretation. He merely challenged the notion that free citizens should have no recourse when their life, liberty, or property interests were affected by fundamental misreadings or erroneous interpretations of the Constitution. Reducing Rhone's arguments to an attack on the court disregards an unwavering standard meticulously and extensively detailed in legal opinions, public statements, newspaper articles, and policy positions. And always the revolutionary Rhone saw danger in the latent designs of ambition and the change to the nature of the general government. Power, he wrote, quote, is construed by the ends to the prejudice of the outs, by the agents of one government in prejudice of the rights of another, and by those who, possessing power, will not fail to feel it and forget right. The appendix in this book contains lengthy excerpts from Rhone's writings in order to let Rhone speak for himself and let the reader weigh his arguments and draw his own conclusions. That, I think, is the role of history, and that is what I tried to accomplish in this book. There was no final resolution between Marshall and Rhone. There are only principles and ideals and visions, and all of that is, I believe, worthy of recollection and study. And that's what prompted me to write this book. And I do appreciate your attendance today, and I'd be happy to answer any questions.
Great, thank you so much. Our first question is, can you talk about something in your research that you thought was interesting that didn't make it into the book?
That didn't make it into the book. As I mentioned, Rhone had a pretty quick temper. He had a great difficulty separating philosophical disagreements from personal disagreements. He blurred the line very quickly. There were a number of these where only portions of arguments have survived, meaning letters or comments made by observers that I really would like to have explored. But because I didn't have both sides of the story, and because there were no letters from Rhone on these various topics or comments, I couldn't explore it. I did put in one comment from his cousin, who was also his political ally and the editor of the Richmond Inquirer. And I did say it's about an unknown disagreement. And I included that just because I felt it was a good example of the frustration that his friends felt with him. But that's an issue that I wanted to explore a little more. But as I mentioned at the start, Rhone's letters are scattered. There's no one place where they are, so I had to find them as best I could. He didn't keep a diary to any extent. So to be true to facts, I had to just go with what I had. But that's something I would have liked to have explored, but I left out a lot because it would have just been halfway stories that would leave a little bit too much to speculation.
Great. Can you talk a bit more about the accomplishments that Rhone had as a justice of the Virginia Supreme Court?
Well, yeah, when he was not involved in politics and when he was just focusing on the court, he was the author of several really significant decisions. He established judicial review in Virginia 10 years before John Marshall did it with Marbury versus Madison on the United States Supreme Court. And one writer about Marshall did a reference that Marshall knew of that opinion and perhaps was somewhat inspired by it. Although if he knew Spencer Roane wrote it, he probably would have tossed it. But so that was the first thing. The second was the established church in Virginia, and the church had been disestablished in many ways, but there were a few remnants left. And Rhone was the author of the principal decision that struck down the established church and affirmed religious freedom in Virginia. And then there was a very interesting decision on the manumission of slaves, the Pleasance case, which Rhone authored. And that dealt with someone who manumission, which means you could free your slaves by your will, was not legal at the time this fellow had passed away. So in his will, he wrote, if it ever becomes legal, then I want my slaves to be free. So many years later, when manumission was allowed in the Commonwealth, the slaves sued to say, okay, we should be free now. And the case went to the Supreme Court of Virginia. And Rhone wrote the opinion that said, absolutely, that they can. And he used some very stirring language in support of freedom and as a general concept. Now, this didn't mean he was on the forefront of emancipation. He was not, unfortunately. But it did allow a slight crack in that. And those are the three prominent decisions. But again, as I mentioned when I was running through the statistics, Rhone was the principal author of many of the decisions of the Virginia Supreme Court for all those years, or influenced the justices who did. There's no question that it was the Rhone court during the years he was there.
Great. Our next question is, what is it about this figure that inspired you to study him more in depth?
Well, because I don't write full time, because I practice law, I know it's going to take me a long time to write about anybody. And so each of the figures I've written about, and this is my third book, I picked someone who I didn't think someone else would do. I mean, if I set out to write a book about Thomas Jefferson, there's a good likelihood that somebody's going to write about him between the time it takes me to write. It took 7 years for that first one, 10 years for my second, and 8 years on this because I can't do it all the time. So first of all, I look for a character that is probably not going to be written about. Second, is the research close by? And with all my figures, they're all Virginian, and so most of the research, the papers that I would want to look to, the libraries I have to go to, are within the general area of Richmond, where I live. I had to go to the Library of Congress some and to Johns Hopkins once, but generally it's not a hard effort to research. And this was before the days of internet, where a lot of papers now I can look at that way. So those are sort of the tactical considerations. Second, I've always thought it was a shame that unless someone became president, you didn't get a book written about you. There are so many interesting people in our history who just fade away because, as I say, they weren't a general, or they become president, or they didn't do one big thing. I've often thought, would anybody at all read John Quincy Adams' diaries, which are fascinating, if he hadn't become president? Would anybody know about Harry Truman's committee when he was in the Senate, the committee that investigated military expenditures, which is one of the great committees and the work that was done in the history of our Congress, if Harry Truman hadn't become president? So I try to find folks that I think are interesting. What prompted me on Rhone was the fact that he and the Chief Justice of the Supreme Court were carrying out debates in the newspaper. And when you read these articles, they don't hold back. Certainly they talk about philosophy and the law, but Rhone punches pretty hard, and so does Marshall. That is, to me, interesting, that you've got the head of the federal judiciary and the head of the most prominent state judiciary battling it out in the newspaper. And so that's what prompted me to Rhone. I also had run across Rhone when I wrote my previous book on John Randolph, because Randolph was a great admirer of Rhone, and that's how I came upon the name. And Then finally, there was a long-standing story, which I debunk in this, that if Thomas Jefferson had had the opportunity to appoint the Chief Justice of the Supreme Court, that he would have appointed Spencer Roane. Instead, John Adams got the appointment, if you recall, in the last days of his administration, and appointed John Marshall. That old saw has been around for a long time, and my research, which I lay out in the book, shows that there's nothing to it. So I felt like this is someone who wasn't known, but who deserves a look. We know all about John Marshall, but we don't know about Spencer Roane, and I thought, well, then why not at this time do one?
Fantastic. Our next question is, what, if anything, do you think that modern day lawyers or legal professionals might learn from this story?
How irascible judges are would be a good start. But no, I think they'll find it very interesting because there are a few stories in there about the local bar associations, how the attorneys handled appearances in court. Patrick Henry appearance in court, I outlined one argument he made. I think it's always interesting for members of the bar to know their heritage as attorneys and to see the figures that they might not otherwise see. And I don't think they'll find anything in Judge Rhone's opinions that haven't been either subsequently outlined in other cases, more modern cases from the Virginia court. So you wouldn't go in a court citing Spencer Roane, although might be a nice touch. But I think the attorneys that could come to appreciate how much it means to be a member of the bar in the Commonwealth.
Fantastic. Well, that is our last question.
Well, marvelous. I do appreciate this, and always a pleasure and a great honor to be associated with LSU Press. It does a marvelous job. Thank you very much.